So, friends, welcome to this crash course on company law. And special target is your coming exam.
Yes, sir.
Crash does not mean anything omitted. Everything is going to be there as if it is a full course. Only difference is speed will be slightly on the higher side. Slightly, not much. Okay. So, except that, no difference, right? And keep one thing in mind that you are here for learning. Keep on asking questions till you really learn. Your objective should be very clear, right? My objective is clear that I need to make you learn. Your objective should also be clear that you are here to learn. Okay. So be very clear about that, that the purpose of your being here, the time which you are investing here, everything you should be learning. And this learning, particularly the law subject, and in the profession of company secretary, this is the only subject where you are expected to have an expertise. And if this expertise is missing, career itself will be doubtful. So you are learning for the career. You are not learning only for exam. So this is another objective I am giving you. So the purpose of learning is for the career. It is for the lifetime, right? So do not concentrate only on exam. According to me, exam is on the way. Exam is not the target. That is not the goal. The goal is being a successful professional. Exam is just in the process, it is a part of that. And that should not be a hurdle. So once you prepare thoroughly, I promise that nobody can stop you. And there is nobody actually who wants you to stop. Only person who is stopping you from success is who is stopping you. Tell me, who stops you from success?
Ourselves.
If I say that institute stops me, then one finger is straight, three fingers are towards me, right? So institute is no way responsible. No examiner is your enemy. Nobody wants you to be here again and again. Everybody wants you to pass. But that depends upon what do you present therein, right? Now, first of all, you have to distinguish very well that having knowledge is not equal to good presentation. Priya may be knowing number of dishes, how to prepare, knowledge. But do you really prepare so well every dish? And how the marks are given? Marks are not on this, marks are on this. So where your focus should be? Where your focus should be? On acquiring more knowledge or on this? I tell you, 90% of students focus here. And they keep on acquiring knowledge for the lifetime and number of attempts, one attempt, two attempt, three attempt, four attempt, five attempt. They keep on doing that only because their focus is on knowledge. And knowledge is not going to give you any marks. What is going to give you marks? The presentation, right? So knowledge is a base, okay, but unless you know how to present your answer correctly, you are not going to score. And just in one line, what is required for good presentation? Lots of writing practice. Lots of writing practice. Now it depends what do you call a lot. 2 page can be a lot, 5 page can be a lot, 20 pages can be a lot. So what is lot? You decide your lot, right? But lots of practice. And according to me, minimum 20 pages a day writing practice should be there. Now writing comes a later. Before you start writing, there has to be a some thinking that what you are going to write and how you are going. So what I was telling you is that before you start writing, you have to think what you are going to present so that it looks better. That is the key. Only writing not going to serve a purpose. Read from the book, write it in the notebook. Read from the book, write it in the notebook. Absolutely wrong technique. Hello, hello, sir. Hmm. So what you are going to write, that you have to think seriously. I said noting down or copying from the book in the notebook, that's not the writing practice. Writing practice for presentation in the exam. Read the question, think seriously what you should be writing, how much to write, right? That you decide first, then only start writing practice, right? I don't want you to spend time on this unless you exactly know what you want to write and what will really look good. And before I start formally, some more information. Your exam is for 100 marks. How much time do you get in the exam to write? How much time do you get in the exam to write?
3 hours, sir.
3 hours is the total time. How much time to write?
So 2.5 hours approximately.
Exactly. Approximately 2.5 hours. Right? So let me put it that you can write for 150 minutes. Okay. And this is also when you know the answer for every question. By chance, if you don't know the answer, or maybe you are not sure, then looking around and thinking at this and that, the time gets further reduced. This is the time because when you get the paper, you read the paper, you plan yourself with which question you're answering first, then after writing every answer, then take a 1 or 2 minutes break in between. How much time is lost, we really do not realize. But the practical is this. Even if you know 100% answers for every question asked in the exam, you cannot write for more than 150 minutes. Right? How much time it takes to write one page? Have you ever calculated how much it takes you to write one page?
No, sir. I haven't calculated.
Do that today. Okay. This will take you around 10 minutes. One full page from the beginning till end. Right? It will take you around 10 minutes. So how much you can write in the exam? You cannot complete your main answer sheet. Then how come in the exam you have 2, 3, 4, 5 supplementaries? Right. So maybe you are writing in such a way that only you can read, not the examiner. And if he cannot read, you become CA. TA means come again. Right? Never do that. Start writing, have practice, right? Then you can have a good handwriting from the beginning till end, at least legible. I know that handwriting is certainly going to be a problem in the exam because you cannot maintain that from the beginning till end. But at least it should be legible. If it is not legible, nobody is going to give you any marks at all. Come again in the next exam, right? So they don't tell you come again, they tell you have become a CA. Come again. Now, how to plan? See here. This is showing you something. For how many marks one question is? If one question is for say 4 marks, how much time you can allocate for writing answer for this question? How much time you can allocate? One mark, 1.5 minutes. Not more than 90 seconds if for 1 mark. If it is a question for 4 marks, how much maximum time you can give to answer this question? Maximum 6 minutes. Maximum 6 minutes. But you really don't know how much time goes while writing an answer for this. So again, practice is going to help you to understand how much time it takes you to write the answer. You have to ensure that you complete the answer within 6 minutes. 6 is max. And if you want to have a cushion to re-look at the answer after completing the paper, try to finish it in 5 minutes. Try to finish it in 5 minutes. So 1 minute saved, this will help you to come back later on and add 1 or 2 more lines thereof. Right. But if this is not planned, what will happen? Right. Otherwise, without planning. For 4 mark question, you end up spending 10 minutes. The next question is for 8 marks. On that, you spend 6 minutes. What will happen? Out of this 4, the maximum marks can be given you 4. Even if you write for half an hour, it will remain 4 only. But if you reduce the quality of answer of this question, it will go down to 3. Is it worthwhile? For scoring this 100%, you have compromised there more than 50%. Never. Start planning. Start writing. More you write, more you learn. And every time you start writing, put a timer. Initially for 1 month, it will help you to understand your writing speed, your writing skills, so you can plan. Right. So when your question is there, prepare mentally what you will write so that answer can be completed within 5 minutes. If you can plan that, it will help you. And if that cannot be planned, it will be hurting. Right. How many times you have heard the paper was lengthy? Very common.
Yes, sir. Many times we find that paper was lengthy
Right. Why it was lengthy?
because we take some time to think about those case studies and everything. So it takes time. And after that, writing. Before thinking and after that, writing.
But the reality is that the paper setter is required to give suggested answer for the question he is asking. And the paper is analyzed thoroughly to check that this can be completed within the allocated time.
Yes.
Right. So where is the problem? Some students do not find it lengthy. Some find it lengthy. Right. So those
Yeah.
who do not find it lengthy, what is the difference?
What?
Why they don't find it lengthy? 2 reasons. Either they know too much,
Yes.
or they don't know anything. For them, length of the answer doesn't matter at all.
Yes.
Right. But knowing in between is the problem. Right. So you
Yes.
need to structure your answers correctly.
Yes.
And that you have to start planning from day one.
Yes.
Today itself, whatever we are going to talk about, you need to find questions. Rather, I can share the questions pertaining to those topics, right? And
Yes.
start writing answer for those,
Okay, sir.
right?
Yes.
So that will help you to really, really prepare well. And this technique, what I'm sharing with you right now, it is not only for this paper. This will be equally applicable for every paper, every exam in the world, whatever you plan for.
Sir, this is going to be very helpful for my students at least.
Very good. Very good. So tell them how to plan. What do you teach?
Absolutely, sir. Sir, I teach business studies and legal studies for class 12.
Business and legal studies. So I cannot teach you anymore. Anyway, 12th is the most important exam in the lifetime.
Yes.
Right.
Yes, sir.
And they have to prepare very well in advance so that they can complete the answer sheet at least 15-20 minutes before completion of time. 15-20 minutes time should be available for reviewing.
Absolutely, sir. They need
Right.
to review it.
They need to. You have to review, because once the information is here, the mind is continuously processing, right? And lot many things you will remember after coming out of the examination hall. Okay, this was also there, this was also there. So why does it happen that you remember that immediately after that you come out of the exam hall? So that time you are little free, and I want you to have that free time before completion of the exam time.
Yes.
Right. So when you have those 15-20 minutes margin, and then you review your answer sheet, I tell you that will give you minimum 5 extra marks. Even if you add one line in each page, what difference it will make?
Sir, it will make great difference. And most of the time I have observed that class 12th students are so excited about their boards, they mostly skip just in the excitement. कि ये तो आता है, इसे तो मैं जल्दी जल्दी कर लूंगा, and they at the end they leave some of the other important points.
Confidence and overconfidence, there is a difference. Right. The person with overconfidence will be too anxious. And the person who's confident, he will be absolutely calm. So there is a huge difference between this confidence and overconfidence.
Sir, in case of CS exam, we don't get time to review because we are
So
till the last moment we are writing, and writing.
I think I have passed that exam.
Yes. But sir, in our case, it's very difficult.
It's not. It's not. Right. And I've been educating for last 23 years.
Yes.
Right. 46 attempts gone. Minimum
Great.
number of students, those CS taken together has crossed 1 million.
Yeah, oh,
Right.
yes.
So not ready to accept these excuses.
Oh, yes, sir. Maybe
Right.
this time onwards, I'll make it.
Prepare. You still have a time. And
Yes,
within 1 month, there can be a big change. I tell you that. Within
sure,
1 month, it
sir.
can be a big change.
Yes,
And this is why I'm telling you before I start the formal teaching.
yes.
Right. So another mistake which is committed, very commonly committed by the students. Right. So student includes all of you as well. Right.
Yes.
So what do? They will prepare notes while studying. Right. Notes are meant for what?
For referring, last moment referring.
For
Quick
reference.
revision. Yes.
For quick revision.
Yeah.
For reference. Right. Without knowing what is relevant, what is not relevant, they will prepare notes. So whether they are preparing notes or they are copy pasting. Right.
Copy
On one
paste.
side, there will be notebook. On the other side, there is a book, there is a notebook. These are notes.
Yes.
Absolutely useless. Complete waste of time. Complete waste of time. When the notes should be prepared, keep the object in mind that notes should be maximum 10% of the total number of pages for that in the study material that you have. Maximum size, not more than 10%. So if this is the material, say of 1,000 pages, these are 1,000 printed pages are there. Your notes, handwritten notes, should not be more than 100 pages. Right? Notes are, these are bullet points. These are not elaborated ones. Right? So how to prepare notes? पहले चैप्टर को, सेक्शन को 6 दफा पढ़ लो अच्छे, close the book and then start writing, right? And then compare again what you have mentioned in the notebook, whether it is having everything which you have read. Otherwise, do the value addition. And then use those notes for the purpose of revision, right? How the revision is done? It is revision. तो अगर पहली बार विजन ठीक से किया होगा तो रिवीजन होगा ना, है ना? पहली बार विजन ही गायब है तो रिवीजन कहां से आएगा? गेटिंग इट? तो आपको चाहिए पहले विजन बहुत अच्छे से, ये राइट, तब रिवीजन होगा. और रिवीजन कभी भी किताबें खोल के, नोटबुक खोलकर, आंखें खोलकर नहीं होता. रिवीजन इज ऑलवेज एट द मेंटल लेवल. Keep the notes in front of you for immediate reference by chance if you miss something. But do not read. Then you are reading, you are not revising. Rereading doesn't help you. Reading is good only for preparing good notes. For revision, neither book nor notebook nor eyes should be open. Close the eyes first of all for revision. That when then you will find that whatever you have read in 5 hours, 10 hours, that is revised in few seconds with the closed eyes. Keep the eyes open, it will not happen. Right? Maximum disturbance is created because of vision. So the moment you close the eyes, your attention will be at one place. It will be easy for you to revise. Right? So whatever we do in the whole day lecture, you will be taking notes. Ensure that before you get up from the chair, you have revised it at least once. Before the end of the day, you should have revised it minimum 6 times. Right? I tell you, if you follow this, forget about preparing for this subject. Right? And once you're learning the technique will remain same for any subject that you do. Done? Any questions? No. So today's topic, which I want to start, is general meetings. Your entire syllabus. Companies Act. How many sections are there in the Companies Act? Total, how many sections? How many schedules are there? How many chapters are there? Thirty. Wherever you find a reference printed, you will find 29. I'm giving you 30 because one chapter has been recently added. Right? So anywhere 29 written, that is correct. Nothing wrong. And sequentially, if you find, number will be 29 only because the chapter added is 21A. So effectively, there are 30 chapters. But out of 32 chapters have been omitted also. So sequence number doesn't change because of omission in law. Sequence will remain same. So 2 chapters are omitted out of this. So 2 chapters omitted are number 1 chapter, which is in relation to sick companies. This chapter is no more there. Another is about voluntary winding up. So these 2 chapters are not there in the Companies Act. So number of sections 470. That is again a sequence. Because of the addition of the new chapter, 46 more sections have been added. Chapter number 21 about the producer company. 46 new sections have been included therein, and these sections which are omitted, again we come back to the same level. So more or less, not exactly 470, but approximately 470 number of sections are there after the omission of these 2 chapters and inclusion of new chapter. This is approximate. Now, out of this, there are 2 parts. Up to section 205 and 206 onwards. This is not in the paper of ACLP. Section 206 onwards, not a part of ACLP. Right? Now, in this also, up to section 205, this you can bifurcate again in 2 parts. Up to section 87 and 88 to 205. In this you find general meetings, accounts, audit, dividend, and directors. Directors topic, section 149 to 205. General meetings, right? So these 3 are very small chapters, very small chapters. Real chapters are these 2 only, general meetings and directors. And these 2 chapters alone will constitute not less than 65% of your total paper. These two topics, general meetings and directors. In directors, there are subparts: appointment, qualification, disqualification, retirement, that is one part; managerial remuneration, that is another part; board meetings, that is the third part. But I call them, all those taken together, as directors. So general meetings plus these two directors topic, these will carry minimum weightage of 65 marks in your exam. That is why I'm taking these topics first, right? And then we will go to other part, that is section 1 to 87. Okay, because that is substantially less as compared to this. So once you have covered up important topic, you also get extra time to revise. You also have extra time to ask me number of questions on that. So I had shared the material on the group. All of you got that?
No, sir.
Material required for reference.
No,
No,
sir.
sir.
Got that?
No, sir. Didn't.
No, sir.
Same here, sir. Even I haven't got.
It is in the group. You are in the group or not?
Yes, sir.
Check
Yes, sir. I'm
again.
in the. No.
I'm in the group, but we have not received it.
Yes, sir. I have not received.
Need to check the group again. When did you check the last time?
Sir, just now. Check
Right
it.
before the meeting. I'll check it, sir.
Check it. Okay, if not there, once again I'll share it after the class is over. Okay, so coming to the part meetings. Yes, Kartikesh, share it in the group once again, so everybody will receive it again. So meetings, what are the essential requirements for meeting under the law? Number one, properly conveyed. First requirement for the meeting, properly conveyed. Now, conveyed means what? And properly means what? Properly means under appropriate authority. There has to be authority. Without authority, you call a meeting, it will not be considered as a meeting for the purpose of law. When we say convene, this is means issuing notice. So these are two words, properly conveyed. So properly means there has to be a proper authority. Authority for what? For convening. Convening means what? For notice. So if we taken together, proper conveyed means the person issuing the notice should have an authority to issue that notice. Now, when we say authority, so this authority given by the act, this authority can be delegated by the board, or this can be there in the articles of association. So somewhere there has to be an authorization to the person who is issuing the notice for this. If he does not have authority, the notice itself becomes void. And if the notice is void, meeting is automatically void. So the first thing required for a meeting is properly conveyed. Is it clear?
Yes, sir.
Yes,
Next.
sir.
Then properly held. Properly held means at the right time, right place. What is the right time and place? As given in the notice. Thank you, Priya. So at right time, right place. This is as given in the notice.
Notice.
Okay. So I'm muting everyone so that you can unmute yourself. Otherwise, it will create a disturbance. Okay. You can unmute yourself. So as given in the notice. So at what time? As given the notice. Which place? As given in the notice. And then another thing required is presence of quorum. So quorum being present at the right time, at the right place, then we say meeting has been held. Held means only commencement. That's it. The word held is commencement. And this is calling. And then properly convened. Properly convening means transacting business. How the business is transacted in the meeting. What kind of voting should be there? Who can vote? How the voting is done? How the results are announced? All things done properly, then we say it is meeting is properly convened to transacting the business. And these words will remain same whether it is general meeting or it is board meeting. No change.
So properly convened, it's mentioned twice, sir. If initially and is
No,
it
sorry,
properly
sorry. This is
conducted?
conduct. I'm sorry, sorry. This is conduct. I'm sorry. Good to tell me. Properly. Good, you reminded me. Thank you. This is called properly conducted. So convene is calling and held and holding means the commencement, and this is conducting. So 3 C's. Three C's. First is calling. Number two, convening. Number three, conducting. If all three are proper, then only your meeting is proper, otherwise not. Any question? No. Now, as far as company law is concerned, meetings there are general meetings and then there is board. Not board meeting, board. In the board, again, there can be two type of activities. One is board meeting, and then there can be committee meeting. In general meeting, again, two types of general meetings are there. One is annual general meeting and another is extraordinary general meeting. Right? So current topic is about the general meeting. So we'll focus there. I've given you that these kind of meetings we are going to talk about. We are going to talk about AGM, EGM, board meeting, as well as committee meetings. Right? What are the activities in AGM? Let us draw another chart. Business, in general meeting. What business can be conducted in the general meeting? Only those which have been included in the notice. So anything for which a prior notice has not been given, that cannot be conducted in the general meeting. No business without prior notice. In board meeting, this is possible. That's why I have intentionally mentioned that only those which have been included in the notice. In the board meeting, this is not. In the general meeting, no business without prior notice. In the board meeting, this is possible. And then we can divide that in two parts. in the annual general meeting and then extraordinary general meeting. In annual general meeting, again, there are two parts. Ordinary business and special business. In ordinary business, number one, first is laying of annual financial statement. Number two, declaring dividend, if any. Number three, retirement and reappointment of retiring director. Number four, auditors. These four are called ordinary business in the annual general meeting. And the business, what is there in the AGM, those cannot be done in extraordinary general meeting. These activities are exclusively reserved for AGM only. These cannot be transacted in extraordinary general meeting. Right. So, other than these four, anything will be considered as a special business. Anything other than ordinary business will be called as a special business. And since these ordinary business cannot be placed in EGM, every business before EGM is a special business. Every business before extraordinary general meeting will be a special business. Right? Now, something about notice for this, let me explain you that. Notice of general meeting. ordinary business and a special business. As far as ordinary business is concerned, generally topic is mentioned. In relation to ordinary business, generally there is no resolution and no explanatory statement. As far as the special business is concerned, resolution. Draft must be included in the notice. Resolution is after the decision. Before that, it is only a draft, it is a proposal, it is a motion. That's why I've added the word draft. Must be included in the notice. And for every item of a special business, there shall be an explanatory statement. Now, what is required in the explanatory statement? Number one, brief background of the subject. Number two, reference of statutory provision. Number three, type of resolution required. And number four, interest of directors. Here is notice of general meeting, not the board meeting. So ordinary business and special business. Okay. So some of the important points I'm explaining one by one. So everything is going to help you later. Everything done? Okay, so now we can go to the formal process and we can start. So this is the material that I have shared with you. And section number 88 to section number 122 all the sections. Then companies management and administration rules 2014 31 rules are there. These are also a part of this material. Coming here, section 88. This says register of members. Who is a member of the company? First question is, who is a member of the company?
The shareholders,
And if company doesn't have shares, then what?
the directors are also, in case of private limited company,
Hmm,
the directors are also a member, a part of the company.
not necessary. I can make you director in my company without being a member. Who is a member? Hmm. What is the definition of the term member? This is the definition of the term member. Section 2, subsection 55. As a student of law, I will advise you only one thing. Do not assume that you know something. That assumption itself can go wrong, right? Try to find whether the word is defined or not defined, right? Quite possible what you understand and what is in the definition, those have no matching at all. Because the definitions are again of two types. Before I go into that, how many types of definitions you have in law? Definitions, general definitions, and a specific definition. General definition usually in the beginning and apply throughout the act, right? General definitions are in the beginning of the law. Usually, there are few exceptions where you will find toward the end also. But generally, definitions are in the beginning, and the definitions which are given in the beginning, those are applicable throughout the act. And the specific definition, these are under a specific section or a provision, and that is relevant only for that section and that provision. right? Now there may be a contradiction in this and this. Then which one will prevail? One word is defined here and it is defined here also.
Sir, specific one will prevail.
Huh?
Specific one will prevail.
Specific one will prevail, certainly. Specific will always have overriding effect over general, right? So here we can close it, and here we can write specific prevails over general. Is it clear? So two types of definitions are in the law, general and specific. Now see here, who's a member? The subscribers to the memorandum who shall be deemed to have agreed. No formal application is required from subscribers to the memorandum to become members. They're deemed to have agreed to become members on its registration, and they are the first members of the company. No formal application is required from the subscribers to the memorandum. Number two, every other person who agrees in writing to become a member of the company and whose name is entered in the register of members of the company. What is the difference in clause 1 and 2?
In clause 1, we don't have to give in writing.
Yes, there is no formal application in writing and there is a deeming provision. In clause 2, there has to be a formal application and there is no deeming provision. And number 3, every person holding shares of the company whose name is entered as a beneficial owner in the records of a depository. So where does it apply? Every person holding shares of a company and whose name is entered in the as a beneficial owner in the records of the depository. Where do you find this?
Listed companies?
Hmm? In the
In the case of listed companies?
आवाज नहीं आ रही.
Listed companies, sir?
Certainly, certainly. It is this clause is meant for listed companies, right? I'll explain that little later. Right now, I'll tell you the difference of what is the general definition and specific definitions. See here. What is the meaning of the term company? Incorporated under this act or under any previous company law, right? So if it is a legal entity created under some other law, how it is referred as? Not created under the company's law, but created under some other act, how it will be referred? Body corporate includes a company incorporated outside India, but does not include cooperative society and the other society specified by the government. So whether body corporate includes a company or not? Company which is incorporated in India, it is a body corporate or not? So company is a body corporate or not? Incorporated under company law. So Companies Act 2013 or Companies Act 1956 or prior to that Companies Act 1913 or 1888. What is body corporate? I'll give you a simple understanding definition. Body corporate means created under law anywhere in the world. What is the correlation between company and body corporate? So every company is also a body corporate, but every body corporate is not a company. Okay, is this clear? Now I'll show you something different. Now this subsidiary company, or subsidiary in relation to any other company means in which the holding company, it means unless there are two companies within the meaning of Companies Act, there is no holding subsidiary relationship, isn't it? If you read the first line, there's a subsidiary company. Subsidiary means in relation to any other company, that is to say the holding company means a company in which the holding company. So then that when the two companies are there, only then the holding subsidiary relationship will exist, otherwise not. So if the other one is not a company under the company law, so whether holding subsidiary relationship will be there or not? Prima facie it will not be, right? Now read this. A specific definition for this clause only. So here company has become broader than the body corporate. Otherwise, body corporate is broader than the company. This is the difference of the general definition and specific definition. What the difference? Right? So much of difference can be created because of understanding of the definition. Okay. Now going back to the definition of the term member. So that is 255. Hmm. So the term member there are three clauses. Clause number 1. This says subscribers to the memorandum are deemed to be members. When they become members, when they subscribe to the memorandum, when company itself is not there, how come they are members? Company is yet to come into existence. So only by subscribing to the memorandum, nobody becomes a member. So add therein on company being registered. So how much difference is created when you thoroughly understand every word, isn't it? Huge difference will be there. So first is subscribers to the memorandum are deemed to be the members. But when company comes into existence, they've deemed to have agreed to become members. So they become members, right? Another category is any person who agrees in writing and based on this his name is entered in the register of members. Number 3, this is only for a listed company. In this company's register of member, it is having the name of depository. And depository is having beneficiary. So every shareholder whose name appears in the register of beneficiaries maintained by the depository. Right? In first two, what is the reference of shares? No reference of shares at all. Right? So to be a member, shareholding is not compulsory. What is compulsory? Right? Another is, in case of company limited by guarantee, there are no shares. Right? If you are an existing shareholder and you have sold the shares, but your name continues to appear there, still you are a member, you have sold the shares. Getting it? So do not use the word shareholder and member as synonymous. These are not synonymous. Right? You can write this way. Member and shareholder are not equal. Done? Hmm. So, register of members. We got stuck up only in the first word itself. Who's a member? So section 88, subsection 1 says every company shall keep and maintain the following register in such form and manner as we prescribed, namely, register of members indicating each class of equity preferentials held by the member residing in or outside India, register of debenture holders. Then index. Hmm. Okay. So read the whole section with me and tell me if there is anything which requires explanation. Otherwise, in any case, wherever required, I'll give you explanation. So subsection 1 says, every company shall maintain, hmm, shall keep and maintain the following register in such form and manner as we prescribe. Number 1, register of members, including separately the each class of members, equity and preference shares held by a member residing in or outside India, register of debenture holder, register of the security holders. Every register subsection 1 shall include an index of the names included therein. So when the index required, when the number of entries therein exceeding 50, the register and index of the beneficial owner maintained by the depository shall be deemed to be the corresponding register. And if the company is so authorized by the articles, keep in any other country outside India in such manner as may prescribed a part of the register referred to in subsection 1, the foreign register, containing name in particular of the member, debenture holders, etc., those who are outside India. And if a company does not maintain register of member, debenture holder, other security holder, fails to maintain them, this is talk about fine. So this section is only one point is there, that is foreign register of members. That is also theory. Practically, you cannot have register of members outside India. Right? You can issue shares in India. Outside India, in any other country, you can issue GDRs, Global Depository Receipts. You cannot issue shares directly in any country. Like any other country, any other company, any multinational cannot issue shares in India directly. They can issue IDR, Indian Depository Receipt. Same is about the Indian company that cannot issue the shares directly to any other country. So there it will be GDRs. So even the concept of foreign register is only a theoretical concept that really does not exist. This is important section, section 89. This says declaration respect of beneficial interest in any share. So where the section becomes applicable. So section 89 this talks about beneficial interest in the shares. Declaration of beneficial interest in the share. So this is investment made by one person registered in the name of another person. Investment made by one person registered in the name of another person. Prima facie, this is something illegal. But this is legal in company law, provided the person in whose name shares are registered, he gives a formal declaration to the company that these shares registered in my name belong to Mr. X. Mr. X also gives a declaration to the company that shares registered in the name of Mr. XYZ, those belong to me. Both are giving a declaration. Right? Why it is allowed, I'm going to explain later on. So first thing required is that when the shares investment made by one person is registered in the name of another person, the registered member as well as the beneficial owner both are required to make a declaration to the company. Company will just keep a record and file the declaration with the government. By this declaration, beneficial owner does not get any right of membership. No right of membership. Then why declaration is required? First thing is, it is no more considered as a black money. That is as per income tax. As per company law, what will happen? That tomorrow, if there is a change of beneficial holding in any way, there is a transfer of share. Actually, who can exercise the right of membership? The registered member. Right. Now, the registered member may not have taken the permission from the beneficial owner. He has already registered, he has already sold the shares to somebody, taken the money and trying to vanish. This section will protect him. If there is any change in the beneficial ownership of shares, again, both of them have to inform the company in writing. This is how the interest is protected. If this is not done, this disclosure is not given, next protection will also not be available. So this is one reason for making the formal disclosure. Number one, protection of interest. Right. Number two, which is very, very, very important to understand. For that, I'll ask you a question. How many number of members required in a private company? Minimum number of members.
200. Sorry. Sorry, sir.
Minimum.
2 7.
Okay. Now you know the concept of wholly owned subsidiary. Have you heard this never anytime before? Wholly owned subsidiary. Right. What is the meaning of wholly owned subsidiary? Holding company is holding 100% share capital. That's how it is wholly owned subsidiary. And if this is one company is holding 100% capital, then how come this requirement will be met? Holding company is holding 100%. And for being a private company, you require 2. For being a public company, you require 7. How come that requirement will be met? And if number of members fall below statutory minimum, what happens? What happens if the number of members fall below statutory minimum? Section 3A. What is Section 3A? Unlimited liability of the members. If number of members fall below statutory minimum, company continues to carry on business for more than 6 months, then the liability of the remaining member become unlimited. Remember that section? In this case, wholly owned subsidiary, 100% capital of the subsidiary is being held by the holding company. How that can be done? Without attracting Section 3A. Right? Now let me take some figures for you. Assume that ABC Limited, it has issued 10 lakh shares. Right? And XYZ Limited right? So ABC is wholly owned subsidiary of XYZ, right? Now, how these will be held? The holding company will have 6 representatives, and each representative will be holding only one share each. And ABC will be holding 9,99,994 shares. one share each held by 6 representatives. So when the shares are held by somebody, he has to make a request to the company in writing to enter his name in the register of members. So who will be member? This representative will be the member for every purpose. Right. So officially there are 7 members, and these 6 they will make a declaration to the company that these shares held by them, actually those belong to ABC. ABC will make a declaration that shares held by R1, R2, R3, R4, R5, R6, those are our ownership shares. Right. These declarations are given to company, and company files that with the central government. Company files the declaration with the central government. So declaration becomes official, and this is no more a black money. This is authorized by law. Is this clear? Hmm. Now see, by making such a declaration, the beneficial owner the beneficial owner does not become entitled to any of the membership rights. He does not become member. Who's a member? All the membership rights are exercisable only by the person in whose name shares are actually registered. So declaration has to be given. The person making the declaration, he does not get any membership rights. Membership rights continue to be exercisable only by the person in whose name shares are registered. Then why to make a disclosure? Reason number 1, it is no more black money. But that cannot be written. Right? No, that is not the subject matter of company law. Right? Otherwise, what will mention that any change in the beneficial ownership has to be informed by the beneficial owner to the company. Only then it will be taken on record. So the biggest protection of interest to the beneficial owner. any change in beneficial ownership is taken on record by company only on being informed by the beneficial owner. Otherwise, it is not taken on record. So, isn't it important? So, understanding the section from 2 points of view. Number one, where it becomes applicable. So, officially, it is applicable where this kind of holding is required of wholly owned subsidiary, right? Otherwise, wherever I deem it necessary for whatever be the purpose, this kind of holding can be allowed. When the shares were not in demat form, this was very, very common. The people who were large investors, they used to give the right of membership to somebody else. Buying, selling is done by them under the instruction of the beneficial owner. Now it is not so prevalent, but earlier it was very, very common thing. So now let's see what is there in the section. See, where the name of person is entered in the register of member of a company as the holder of shares, but who does not hold the beneficial interest in such shares, such person shall make a declaration within such time and in such form as be prescribed to the company, specifying the name and other particular to the person who holds the beneficial interest in the share. First part, right? So who's making the declaration of subsection 1? The register holder. In subsection 2, every person who holds or acquires a beneficial interest in the shares of the company shall make a declaration to the company specifying the nature of his interest, particulars in the of the person in whose name the shares are registered. Then, where such change occurs in the beneficial interest in the share, the person referred to in subsection 1 and the beneficial owner in subsection 2 shall, within a period of 30 days from the date of change, make a declaration to the company containing particulars. Without this declaration, the change will not be effective. So this is how the interest of beneficial owner is protected by law. Subsection 4 is only giving the right to the government to make the declaration. And if the declarations are not made, what happens? That is subsection 5, those are penalties. And usually you will not find penalties in the exam. Generally, exams are not penalty based. Subsection 6. Now, where a declaration under this section is made to a company, the company shall make a note of the declaration, the register concerned, and shall file within 30 days from the date of receiving the declaration a return in the prescribed form with the registrar, that is the ROC, in respect of the declaration with the additional fees as may be prescribed. So, both are making declaration to the company, company is making filing it with the ROC, so this becomes an official declaration made to the government. Number 8. No right in relation to any share in respect of which a declaration is required to be made under this section, but not made by the beneficial owner, shall be enforceable by him by the person claiming through him. No membership rights are given to the beneficial owner. All the rights are exercisable only by the registered owner or member. Subsection 9 is only a clarification. This says nothing in this section shall be deemed to prejudice the obligation of company to pay dividend to the members under this act, and the said obligation shall on the payment be discharged. So dividend will also be sent to the registered holder only. It will not be given to the beneficial owner. Number 10. For the purpose of this section, section 90, beneficial interest in the share includes directly, indirectly through a contract, etc. So what is the meaning of beneficial interest that is defined? So that I've already explained. Investment made by one person registered in the name of another person. So that is one. Then register of significant beneficial owner in the company. This is something different. This is talking about the more than 10% shareholding. So about this section, we will talk after the break. And break time is between 1 and 2. So we will meet now at 2 o'clock, right? Log in again at that time. In the meantime, this video will be processed. So we are meeting at 2 o'clock again. Thank you.
Okay, sir. Thank you.